We've got a question here by Mark. Mark asked for assistance regarding what would be a reasonable cancellation fee from a tenant's perspective when it comes to terminating a lease agreement early. Mark says he has never laid a foot out of place when it's come to his lease agreement, and he's been, to the best of his knowledge, a model tenant. He unfortunately had to cancel his lease agreement slightly early by a single month, and he gave his landlord 33 business days notice, even though it was only 20 days that were actually contracted or stipulated in the contract. His landlord is now saying that she's well within her rights to charge for that month, which would have been his last month in terms of his lease agreement. And she's going to charge that fee if she can't place somebody else, a new tenant, in the property. Mark says that the lease agreement further states that she is able to charge a maximum, in terms of the contract, of 2 months' rent when an early termination is requested. Now, we believe that she's only asking for the single month, that's the outstanding month to come. The lease agreement also requires him to pay pro rata commission of the lease, which is 1/12, and a reasonable cancellation fee, which is the basis of his question this evening. So Mark asks three questions. He says, what would a reasonable cancellation fee be? And since this reasonable cancellation fee is not written in black and white, who decides what this fee should be? Is it the landlord? Is it the tenant? Does the managing agent get involved? And then he wants to know, I'm going to throw this in there quickly, does he have any grounds to dispute the cancellation fee? Taking into account that he's been a model tenant and also the fact that he's provided sufficient notice to his landlord. Bruno, you want to tackle this one?
So I suppose, look, there's a legal answer to this where we can explore everything that's happening, and then there's a practical answer. I think let's start off with the practical answer first, because at least, at least in the context is set. If there's 1 month, if there was an early cancellation, which landed up with 1 month left on the lease, 1 month is not a lot. And that's very common. The problem that we find is it sometimes takes about a month to find a new tenant to a property. So practically speaking, you have a 12-month lease, you cancel early. Now the landlord needs to rush around trying to find someone to put on this property so that they don't suffer any sort of loss or any sort of damages. If there's only 1 month left on the lease and there's no one that's able to take occupation of the property, practically speaking, it does actually make sense. And prior to the CPA, the way that we actually used to do it as lawyers is we used to look at the reasonable period it would have taken to actually put somebody new on the property. And that's how we'd calculate damages. If we translate the concept of damages, which is pre-CPA, into what a cancellation penalty is supposed to look like, you get very similar results out of it. So that's not the legal answer to it, but the practical answer is, unless you can show that the landlord did everything but put somebody in the property, typically speaking, it is reasonable. And you often find that in the lease agreements, they normally make provision for 1 to 2 months. And that's become an industry norm. It's just what's being charged nowadays, especially in residential leases, specifically because that's the amount of time it takes to find somebody else. Pro rata commission also does make sense because you pay, if it's a placement fee, so it also depends on what the cost is. So if there's an actual placement fee for a tenant, that means now you're going to need to pay again to get somebody in for the duration, for that extra one month in a brand new lease. What sometimes you find is there isn't a placement fee and agents are just charging monthly and they don't charge anything ahead, but that depends on the mandate with the agent. So one can claim it and call it damages or call it some sort of loss if they are actually incurring it. But from a legal perspective, now obviously this easily flows into the legal answer, which is early termination is permissible. A tenant is allowed to do it on 20 business days notice. The lease agreements typically do always provide for some sort of clause or cancellation, reasonable cancellation fee if somebody does want to cancel cancel early. And, sometimes this carries an upside or a downside. The reality is the reason why it's in the lease agreement is because at least it's in writing. It's stated, everyone agrees to it beforehand, which makes it easier to enforce. Whatever that might be it 1 month, 2 month, the landlord is entitled to ask for it. You normally find that is considered to be reasonable. Yes, one can dispute if for some reason it's not reasonable, but also just bear in mind, if you sign the lease agreement, there is an expectation that typically you would have read it. But yes, if it's totally unreasonable, you would be able to dispute it and show cause why that penalty shouldn't be allowed. In a case where it's only 1 month left on lease, I highly doubt it's not even feasible to go and spend the time to dispute it.
No, thanks, Bruno. Really appreciate that answer. And I hope Mark's watching or tuned in. If not, Mark, you can always contact Bruno or Cilna later on as well.